o'clock, so we will call this meeting back to order. Please note for the records that Jenny had to leave, so we've got both Rick Tisch and Jenny not here for the last part of this meeting. All right, so with that, we are on G.1, which is consideration of proposals for decision. And I will turn it over to John to take us through G.1.1.
All right, the first one we're going to look at today is for Ms. Reeves. And on May 29, 2025, a proposal for decision was issued by an administrative law judge, or ALJ, of the State Office of Administrative Hearings in the matter of contested case TSBP for Sarah Ann Reeves. For procedural history, Ms. Reeves holds pharmacy technician registration 312237. The ALJ in that case found by the preponderance of the evidence that Ms. Reeves on June 6, 2024, received deferred adjudication for the second-degree felony of manslaughter. The underlying offense involved a motor vehicle. In the proposal for decision, the ALJ concluded that under Board Rule 281.64, a suspension of 180 days followed by a 5-year probation is an appropriate sanction. Board staff agrees. Therefore, staff has prepared a board order for consideration, which imposes the recommended 180-day suspension followed by a 5-year probation, which is consistent with the recommendation of the ALJ and the informal conference panel. I will remind you, or ask you to remember, that Board Rule 281.60b concerns the board's role in discipline, and that rule provides that in these matters, the board is not bound by the recommendation of the ALJ, and the determination of the appropriate sanction is reserved to the board itself within the scope of the Pharmacy Act and the Administrative Procedure Act. And I do not believe Ms. Reeves is here.
Seeing that she is not, board, do you have any questions for John? Comments? What is the pleasure of the board?
Do we just need to?
Do we want to stay with the staff's agreement or the staff's recommendation?
Yes, ma'am. I would like to go with the staff's recommendation.
So we have a motion from Donnie and a second from Ian to go with the staff recommendation. All those in favor? Any opposed? All right. Go, and John, you want to take us to G.1.2?
Yes, Madam President. The next one regards Dr. Frempong. And on April 8th, 2025, a proposal for decision was issued by an administrative law judge, or ALJ, of the State Office of Administrative Hearings in the matter of the contested case of TSBP versus William Frempong. For procedural history, Dr. Frempong holds pharmacist license 56993. The ALJ found by the preponderance of the evidence that Dr. Frempong, while acting as Odessa Regional's PIC, failed to properly supervise pharmacy personnel by allowing a pharmacy technician to perform duties at the pharmacy with an expired registration, which violates board rules, laws, and regulations. In the proposal for decision, the ALJ noted as a conclusion of law that the board could assess an administrative penalty of $1,000 against Dr. Frempong's license. But the ALJ's recommendation was for the board not to assess an administrative penalty. Board staff does not agree with the ALJ's recommendation. Board Rule 281.65 lays out the schedule for administrative penalties for this specific violation. The ALJ and Dr. Frempong are essentially asking the board to ignore its own rule and treat Dr. Frempong differently than previous licensees have been treated in the past, numerous times for this exact same violation. This is likely just the case of an oversight by a PIC, but it is a violation of a very specific sanction, that should be consistently implemented by the board. Dr. Frempong had a responsibility, a duty as the PIC, to ensure all the technicians had valid registrations, and he failed in that duty, and this violation occurred. Therefore, staff has prepared a board order for consideration, which imposes the standard $1,000 administrative penalty, which is consistent with the recommendation of the informal conference panel that heard this case. That is staff's strong recommendation to maintain consistency and discipline. The other option before you is for the board to ignore the violation and take no action against Dr. Frempong's license. Please remember that Board Rule 281.60b concerns the board's role in discipline and provides that in these matters the board is not bound by the recommendation of the ALJ, and the determination of the appropriate sanction is reserved solely to the board itself within the scope of the Pharmacy Act and the Administrative Procedure Act.
All right. Thank you, John. I believe at this time, Dr. Frempong is here as well as his attorney. Yes, please. If you would both please introduce yourselves.
Certainly. I'm Derek Davis with the law firm of Cooper and Scully here on behalf of Dr. Frempong.
My name is William Frempong, Pharmacy Director with Odessa Regional Medical Center.
All right. I will give you the floor then.
Thank you. I think the characterization by board staff is incorrect. We are not asking the board members in any way to ignore the violation. In fact, Dr. Frempong, if the ALJ wrote a very lengthy 20-page analysis of the facts underlying the case, which were all stipulated, with the exception of the mitigating factors. This case proceeded to hearing in very short order on a completely stipulated set of facts. Dr. Frempong wrote a letter even before I got involved to the board apologizing for this particular event. What we tripped over in the process of trying to negotiate an agreed board order is that the usual fine comes with a very heavy penalty in West Texas, and anywhere else in Texas for that matter, but it's especially heavy in West Texas as distinct from somewhere like Houston. And that is that there was a little confusion at the informal conference as to whether he would be precluded from being a preceptor. However, the law is very clear. The board rule says that a preceptor will lose his license for 3 years when disciplinary action takes place. There's a secondary rule here also that because this relates to a licensure violation, a remedial plan is unavailable. So in this particular case, as is set out in the order, the pharmacy license was punished. A CQI was put into place requiring reports quarterly to the board for the pharmacy license. The technician was sanctioned. But the underlying facts of this case are very important, which is why we proceeded to the formal hearing, because this wasn't just a routine violation. This was actually a violation that occurred because of a pre-existing policy at the hospital that Dr. Frempong had relied upon. He took the position right around, I'm going to make up a date, but it was about November 22nd. That date is exactly in the order. And this particular technician's license expired on the 1st of January. Or December 31st, meaning that it was a very, very short period of time after he took over. Unfortunately, the hospital policy required them to notify the pharmacist in charge of the expiration. That notification went to the prior PIC. Dr. Frempong discovered this when he was putting through an application to the board for Odessa Regional Hospital to have a clinical pharmacy program and expanded tech duties. This technician wasn't part of the proposal, but that's when the discovery was made that this particular technician's license had expired. He doesn't dispute the violation or that the PIC has general responsibility for it, but the law requires the board to actually take into account mitigating factors. Those mitigating factors are set out at page 5 of the opinion. And they include 8 things, page 5, and they bleed into page 6. The only mitigating factor that the judge found did not apply to this circumstance was mitigating factor number 6, involving treatment or monitoring for an impairment, which wouldn't apply in this case. The other 7 all applied. The judge found that. And the reason we're here, frankly, is that because he would lose his preceptor license, he's accredited with 3 different pharmacy schools in Texas there's no pharmacy school in Odessa or Midland. So it's very, very difficult to recruit pharmacists to West Texas. I know I don't have to tell some of you that. I know some of you struggle with it. And it's not the same as Houston, Texas. If you give a preceptor this kind of discipline, there's a preceptor probably down the street at the Eckerd or CVS these days, right? I'm showing my age. Sorry about that. But that's why we're asking the board to take the mitigating factors seriously as it's required to do by law, to find that Dr. Frempong he violated the law, and that's very clear from this. In the technical sense, he's got responsibility for what happened. It wasn't his license. It wasn't the pharmacy's license. It was another individual who unfortunately let this thing lapse. It does happen. We get that, and we understand the need for the board to enforce the law and the rules. But the punishment here is severe for Dr. Frempong and his hospital. He has those affiliations. He's got students lined up starting again this fall for Texas Tech, will be the first student. He also has students for University of Texas at Austin. And he just recently finished with a student from the Massachusetts College of Pharmacy, where there are plenty of pharmacists up there. Pulling those pharmacists down into West Texas is tricky. And if he can't do that, that's a major problem. Now, we did raise this with the board in trying to negotiate an agreed board order. What we were told is that the board cannot consider, as part of this proceeding or even an agreed board order, that there's a waiver procedure for a preceptor. We originally submitted that waiver so that we could get this over with and not waste anybody's time here. And at the same time, we were told the procedure won't allow us to do that. The board cannot consider this. They must consider whether discipline is necessary. So that's why we went, just so you know, this wasn't about picking a fight with the board or its right to discipline. This is about allowing Dr. Frempong not to have to cancel his students and his best way to recruit to a place like Odessa that doesn't have a pharmacy school. Dr. Frempong, as I said, everything.
I think you did. Yeah.
Okay.
Thank you.
Thank you.
All right. Board members, what questions do you have? I'll start with one question. So at your hospital, are you the only preceptor there? And I guess let me start with this. How many pharmacists do you have at the hospital?
I have a total of 5 full-time pharmacists.
And of the 5 full-time, are you the only preceptor?
I have one other preceptor, but the schools usually authorize a preceptor for the hospital, and my other preceptor is not authorized with any school at the moment. And the other thing is usually we like to have an extra preceptor just because I won't be there 24/7, and they can assist with it just to make sure we stay regulatory compliance with the board rules.
Okay. And then I guess a question for Megan, just so that I'm clear, everybody else is clear. So what we're looking at is just the licensure. Once that's decided, then the exception can be filed.
Correct. So this is Rule 283.6 in our rules, and that provides when the order is entered, he'll be subject to discipline. And so, like they said, the preceptor license would not be able to continue. However, once that order is entered, as soon as it's entered, they could submit the petition, and that could be granted to allow him to continue. There's some factors in 283.6 that you would look at, but it seems like those factors would be at play here. Obviously can't make any promises, but they could petition as soon as that order is entered to continue as a preceptor.
Okay. What other questions?
Yeah. Is that option something you're agreeable to if we went down that path of it and then?
Let me say it this way. I feel like our hand was forced here. I think it's a great question. Our hand was forced. And it's not anybody at the board's fault or board staff's fault in any way, shape, or form. But the way the rule is written, it can't even be considered in the context of this disciplinary procedure. This order is the record. And so he will absolutely have to do that if this board decides to enforce it and ignore all of the mitigating factors. But we had to put on the mitigation evidence because that wasn't an option at the ABO level. I don't think it's an option for us to even discuss it here. But clearly, Dr. Frempong needs to teach. I think it's good for West Texas, and I think I get it. There's a real hesitation not to look. We do it every time. We can never be inconsistent with that, but that's not what the law says. And this ALJ took a lot of evidence, asked a lot of questions, even used the term, I think it's page 13. It's a pharmacist desert. It was a term I had actually considered before this proceeding, but I think it's a serious problem. And what serves public safety is in or no discipline here, as was recommended, and then we don't have to guess what's going to happen next.
Aisha.
So I understand what you're saying about imposing this could be a detriment to the greater good. Okay. If you would, for me, setting that aside, okay, because I think anytime that there's a consequence, there are natural consequences that come with that, whatever that is. Help me understand just in terms of the actual penalty, talking about being assessed, if you have reason for it, why you feel that that is not an appropriate penalty, other consequences notwithstanding, please.
I can outline a couple of reasons that I think. Recently, I don't do a lot of representation before the board. I know some of you because of the nature of my law practice, but I don't necessarily come before the board very often. But I get retained a lot more these days by pharmacists in charge, in part because they are all fearful of exactly this situation, which is a personal attack on their license when something technical goes wrong in a hospital setting. And it's really been interesting to me because that's not something I've seen in a long time. I've been practicing 30 years. And I would say that's something new in the last 5 or 7 years. Not all directed at this board in any way, shape, or form. It's more of a fear of, my God, my license is on the line. PICs are not compensated for being a PIC. That's a board rule that requires a pharmacist in charge to be in charge of a pharmacist. You guys need somebody who's going to show up and explain to you what happened. But I think there's a real potential chilling effect where the board puts a PIC gets punished every time. Does not matter that you had 7 out of 7 mitigating fact. Those don't matter to us. We've just got to make sure everybody has a healthy fear that if a violation occurs, you have vicarious liability for it. I kind of think that just answering to the hospital management about why is the hospital license getting fined here is a serious consequence for any PIC, especially the new guy on the block. That's how I would react to that. I mean, I think it's not necessarily about the $1,000, if that makes sense, but it's about the discipline. Honestly, I think you guys should very seriously consider a rule change to allow a remedial plan, or at least the interpretation that a remedial plan would be available to someone in this circumstance where it's not the pharmacist license that went, it's not a pharmacist who makes judgment calls. This is a non-judgmental, task-based position, and it's just an administrative glitch that absolutely was fixed the minute this happened. It will never happen again at that hospital or under Dr. Frempong's. And our judge was pretty clear on that too. I just think, I think we end up risking that PIC position becoming something that pharmacists are fearful. And if you guys aren't already hearing that from pharmacists, I'd be surprised. That's just been my experience.
So, and I guess, Haisha, since you're public and new, just for a little bit of clarity, so the PIC is not just a hospital position. So every retail pharmacy has a PIC. Every retail pharmacy PIC is responsible for all of the licenses in their pharmacy that they are current and in date. And I don't know about hospital, but retail, we do, our PICs all make, have additional monetary remuneration for the fact that they're a PIC. So it's not just a hospital, it's in all of our All of our practice settings.
Yeah, they can. But it's a PIC is technically a board term. It's not technically a hospital or retail term. That's the way that's what I mean.
Any other questions? Yes, Randy.
So I just want to make sure I kind of understand some of the timeline around the violation and kind of the technical things you're talking about. And I think I get it, but so basically it sounds like, there was a time point a few months before the violation actually occurred where you'd assumed as PIC, there was a process built that you had partnered with HR because they'll typically manage licensure and things like that at a hospital setting. And they had a process where basically when someone was coming up for 30 or 60 days or whatever it is, that would get emailed to whoever the department leader is, who's usually also the PIC, right? And that was not set up to be you. So that ended up not being, it didn't get sent to you. It kind of maybe it went to an email address or something that was the previous PIC. Did I get that right? Is that?
Yes. So it basically went to the previous PIC instead of my email.
Okay.
But that was within about a month when I started. And so there were a lot of moving parts trying to set up the clinical program. And so knowing that HR had that part being handled. And initially I did look over the licenses. There were no licenses coming due. And so I kind of channeled most of my energy on the clinical program. And that's what led to me applying for the Tech program to kind of free up some space for my pharmacist.
Okay.
So you knew it was a short dated license though?
I did review it and there was no license that was expiring at that moment.
Yeah. On page 12 of the opinion, she sets out the time frame. I can't memorize all this stuff with everything else, but he was the PIC for 43 days before the registration expired on the timeline.
Is that text still there?
No. That tech was actually the moment the incident happened, the tech was taken out of the schedule until he renewed his license. But in about a few months, the tech we had to let him go because we had other concerns.
Other questions?
Just one more, sorry. What exactly do you have in place now to prevent this from happening again?
Currently, we've modified our HR policy. We've also ensured that the supervisors or the directors, including myself, are currently monitoring the licenses. What we had before is HR will email the directors 3 months prior. Now we've set up our policy to allow HR to email 3 months, 2 months, a month, and 15 days prior to the expiration of the license, it gets sent to the director supervisor, which is usually senior leaders. In my case, it's the CMO. So the CMO will follow up with the supervisor in charge. And I also have my quality improvement measures that I report to our quality council every month, going over licenses and ensuring that there's no expired license coming up in the next 2 to 3 months.
Other questions? All right. So we have one prepared board order. So the question is, what is the pleasure of the board?
I have a question. Would it be appropriate to get some legal counsel on this through an executive session?
If you want to.
I would like to, if it would be okay with the group. Thank you. I just have some questions for Megan.
All right. So let me get here we go. Got the right words. And we will have to take a vote on this. But let me read these words and then we'll take this vote. It's come that we want to have a closed meeting to now be held for the purpose of consulting with legal counsel regarding pending or contemplated litigation under the authority of the Texas Government Code, Section 551.071. Do we have a motion to go in executive session? We have a motion from Donnie. Do we have a second from Randy? All those in favor? All right, it is August the 5th at 1:25. We will show that this meeting will now go into executive session. Please note that there were no final actions, decisions, or votes taken on any manner while we were in closed session. It is now August the 5th, 2025, and it is 1:35, and we will show that our executive session has ended. All right, board members, at this time, I will ask the question again. Do we have any questions, comments? Yes, sir.
Did have a question about, could you explain what was meant by the waiver that was discussed earlier? I don't think I entirely understood.
Yes. So that is in Board Rule 283.6. And it provides that no pharmacist may serve as a pharmacist preceptor if his or her license to practice pharmacy has been the subject of an order of the board imposing any penalty set out in this part of the act during the period he or she is serving as a pharmacist preceptor. And then there's a part about or within a 3-year period immediately preceding the application. And then it goes into provided, however, a pharmacist who has been subject of such an order of the board may petition the board in writing for approval to act as a pharmacist preceptor. And then it provides some considerations in determining whether or not to approve that. So once a pharmacist has become subject to a disciplinary order, they can petition and get approval to begin acting as a preceptor or continue acting as a preceptor.
Thank you.
Any other questions? Yes, Aisha.
Please help me understand why you're opposed to the waiver process. Where's the roadblock here?
Sure. So it's a great question, and I'm glad you asked it. What we've been told is that procedurally, this is a matter of order, kind of a point of order, that the board cannot consider that waiver as part of the disciplinary process. I don't know why the rule's written that way or interpreted that way, but that's the way we were. I mean, I've got an email that very clearly lays that out from board staff. They would not discuss with us a waiver on the front end, even a nod, wink, wink. Are we going to get this? I mean, I need to advise my client of this. I think any good lawyer would probably try to look before we take the tremendous expense to go get a 20-page opinion on no discipline. Can't we at least get some kind of heads up on where we're going with this? We were shut down entirely on that front. So my objection is more procedural at this point. It's kind of like, it's nice to say it now, but this was not on the table at all during the agreed board order stage. We were told, sorry, you guys can either proceed to hearing or you can accept the discipline now and take your chances. I think the rule should be written backwards from that, personally, for obvious reasons, because I think it makes everything we just went through for the last year way unnecessary. But that's my objection to it, and I think Dr. Frempong, you probably agree with that.
Any other questions, comments? What is the pleasure of the board at this time?
I'll make the motion to accept the informal conference outcome that we originally proposed of the fine and the penalty as imposed.
So we have a motion. As a second, Ian? We have a second to go with the board order as is. All those in favor? All those opposed? Show that we have one opposition. The motion does pass. Thank you both.
Just to clarify, what just transpired is the $1,000 administrative penalty's been awarded by the board.
That's correct.
Thank you.
And now the waiver can be applied for.
Understood. Thank you.
Thank you.
All right. So the only thing left on the agenda is I. So the first thing is just I.1. As always, my request or ask, is there anything that needs to be placed on our November 4th agenda? Seeing none, I'll move to I.2. We do have informal conferences September 9th through the 11th. Multagon, which Danny will be attending, will be in Norman, Oklahoma, September 21st through the 24th. It's not on there, but District 6, 7, and 8 meetings will be October 5th through the 7th. And then we have informal conferences October 7th through the 9th. NABP's Pharmacy Forum will be October the 27th through the 30th. And then our next meeting will be November the 4th. So be sure that you have that on your calendars. That takes us to I.3. We have a special recognition of service. And I want to make sure the live feed hears this. So I'm going to go ahead and do this without standing at this point. But the Board of Pharmacy would like to recognize Bradley for all of his courage and ability in stepping forward to be the board's first tech. I think he set the bar high for our board, but he also set the bar high for all of the boards across this nation in showing what great value technicians bring to boards of pharmacy. Bradley has served 2 consecutive terms under 2 governors, and we are very grateful for his service to the board. And at this time, I want to recognize the fact that TSHP has given you a letter of recognition, and then present Bradley with his badge and a plaque in recognition of outstanding service to the Texas Board of Pharmacy and to the citizens of Texas, board member from 2013 to 2025. And I'll give Brad a moment to address the board.
Thank you. So I just have a few words here. So I've got this labeled, I'm sorry, emotional. It's been an honor and a privilege to serve as the first technician on the State Board of Pharmacy. Reflecting on my original appointment, I sincerely thank, and in no particular order, the Texas Society of Health System Pharmacy, the Texas Pharmacy Association, and the National Association of Chain Drugstores for their sponsorship. I hope through my participation as a board member that I have contributed to how the State Board operates, improves the operations of pharmacies throughout the state, and help the citizens of Texas with improved confidence in pharmacy. We advertise to the pharmacy world that if you have a question regarding regulation, law, etc., to contact the board. The board staff will provide the correct information that you can use in your particular situation. As appointed members of the Board of Pharmacy who represent all of pharmacy in the state of Texas, I highly encourage attendance at the annual conferences of both the TSHP and TPA. This sends a message that we, the board members, are approachable by our constituents. My hope is that the board continues the presence and enforcement of all pharmacy regulations for the citizens of the great state of Texas. Additionally, I hope my technician successors will continue to strive along with their board members to uphold all of the rules and regulations. Lastly, I wish the Board of Pharmacy continued success in the state of Texas and beyond. Thank you very much.
Thank you, Bradley. That concludes our agenda. So at this time, I will entertain a motion to. Donnie has a motion to adjourn. I have a second from Ian. All those in favor?
Aye.
Any opposed? I hereby adjourn this meeting of the Texas State Board of Pharmacy.